The article of impeachment has been delivered to the House of Representatives unconstitutionally, in my view. I predicted, you heard it, that the Chief Justice would not preside, that the Vice President would not preside, and that Senator Leahy would preside. Prediction one has come true. I also have predicted that the Senate will go forward with a trial, though it's unconstitutional, and that they will ultimately acquit on the ground that they have no jurisdiction. So you've heard my predictions. You can test them. And now you'll hear why I make those predictions on the Dershow. Last night, we watched as House managers, led by my former student Jamie Raskin, walked the article of impeachment from the House to the Senate. Ironically, they walked through the very areas that just weeks before had been taken over by violent protesters who illegally and unlawfully and improperly and immorally had taken over the Capitol. But yesterday we saw a peaceful march of members of Congress seeking to deliver the article of impeachment to the Senate. What we saw was peaceful, but it was unlawful and unconstitutional. For several reasons, as you've heard before on the Dershow. First, the article of impeachment itself violates the Constitution because it charges the president with a high crime and misdemeanor for delivering a constitutionally protected speech. So that's point number one, where what they did yesterday in going to the Senate with the article of impeachment was unconstitutional. It put them above the law. No one is above the law. We hear that over and over again from members of Congress, and that applies to everybody but members of Congress. So that was violation number one. Violation number two, they sought a trial in the Senate of a former president, which is not permitted by the Constitution. The Constitution seems fairly clear in its terms that the purpose of an impeachment is removal. In fact, the best proof of that is the article of impeachment itself. Remember, the article of impeachment was drafted by Jamie Raskin. He says begun to be drafted while he was under siege in the Capitol itself. But it was drafted while President Trump was still president of the United States. And the article of impeachment calls for as a remedy, as the prime remedy, his removal from the presidency and also his future disqualification. But the primary object of the impeachment article, as written by this House of Representatives just a few weeks ago, is removal of the president. There's a concept in law known as mootness. When you've achieved your purpose, the case is dismissed. They didn't even bother to go back and redo the article of impeachment, to change it, to say this is an article of impeachment not against the president of the United States, which is what that article of impeachment says, but against the former president. And the purpose is not removal because he's been removed. The purpose is disqualification from running again. They didn't even do that. And so I suspect the first motion that's going to be made by the Trump defense team, of which I am not a part, but by the Trump defense team, will be a motion to dismiss the article of impeachment on the ground that it's anachronistic. It doesn't apply. He's been removed. It describes him as the president of the United States. He's not the president of the United States. And so that's another illegality that we saw in the halls of Congress yesterday. Then, of course, they're seeking a bill of attainder. They want Congress to put a private citizen on trial. Bill of attainder provision of the Constitution prohibits that. It basically says, as interpreted by the courts, that you cannot name a specific individual, Donald John Trump, and put him on trial legislatively if the consequence could be a punishment. And the courts have been clear. Punishment includes disqualification. So it fits neatly in the prohibition against bill of attainder. And so we saw a lot of illegality. I don't want to compare peaceful illegality with the violent illegality that we saw weeks ago. But nonetheless, we saw illegality yesterday. And so there are going to be motions. Again, the first motion, I think, is going to be to dismiss the article of impeachment because it no longer is applicable. It seeks the removal of a president from being the president of the United States. That's been accomplished by the vote of the Electoral College, by the swearing in of President Biden, and by history. So you don't need a Senate trial to accomplish that. So that, I think, will be the first motion that could be made. A second motion would be to demand a fair, objective, and neutral presiding officer. Remember, the Constitution provides that if a president is on trial, then the Chief Justice must preside. The Chief Justice is not presiding. Neither is the Vice President, who is the usual presiding officer of the Senate. She is the president of the Senate. And presumably, because of what we've said on this show, she didn't want to be in a position of a conflict of interest. Again, I predicted accurately on this show and on other shows that Leahy would be selected. He is the president pro temp of the Senate. He's the elder statesman of the Democratic Party, and he's a decent guy. I've known him for a long time. He's fair and decent. But he already voted for impeachment last time around, and his objectivity will clearly be questioned by those who are doubtful about the fairness of the Senate and about the politicization and weaponization of the impeachment provisions of the Constitution. So who's left? Who could preside? I guess they could make it up and bring in another judge if the Chief Justice won't preside, but that's not in the Constitution. And so they're going to have to make it up. Why do they have to make it up? Because the framers never contemplated this situation. The framers never intended a former president to be put on trial. If they had, they would have said the Chief Justice shall preside when the president or former president or potential future president is on trial, because the stakes are so high. It's not like a judge. There are thousands of judges and hundreds of executive officials. There's only one president. Now there are maybe two presidents because they're putting Trump on trial as the president, even though he's no longer the president. So another motion will be to try to get a more objective and fair presiding officer. That will fail because the Senate has enough votes to go forward with their agenda. The Democrats now have 50 votes. They could lose one or two. Senator Manchin has indicated some concern about what's going on, but they could also pick up 3 or 4 or 5. Remember that 10 members of Congress voted for impeachment this time around. So we're going to see a bunch of motions, and then, of course, the major motion, which we know will be coming, will be a motion to dismiss the trial on the ground that the Senate has no jurisdiction, that they lost jurisdiction the moment President Biden was sworn in. Now, again, I predicted on the show, and I stand by my predictions. I'm not going to make any Super Bowl predictions. All right, look, I prefer Brady because he's an old guy, like I'm an old guy. But I think Mahorn probably has the better of it. But I'm not making any predictions because I'm not an expert on football. But I am an expert on the Constitution, and I predicted accurately that the Chief Justice wouldn't preside, that Vice President Harris wouldn't preside, and that Senator Leahy would preside. I predicted that accurately. And now I'm predicting, as I have, that the Senate will vote by a majority vote to allow the trial to go forward. Unconstitutional, wrong, but they have the votes, so they'll do it. And then he'll be acquitted in part on the ground that the Senate didn't have jurisdiction. How does that work? Well, very simply. You need only a majority to go forward with the trial, but you need 2/3 of those present to vote for conviction. And there are enough senators who don't believe the Senate has jurisdiction to exceed the 1/3 necessary to block a conviction. So we're going to see a repeat of what happened in 1876 when the Secretary of War Belknap, close vote that the Senate did have jurisdiction, and then when it came to convicting him, everybody said he was guilty. He committed impeachable offenses, but 23 or so senators said, no, you don't have jurisdiction. And they voted to acquit. So that's not a precedent going forward for the Senate having jurisdiction. It's a very mixed precedent. And I think we're going to get another very mixed precedent. We're going to get an acquittal largely on the ground, combined grounds, but largely on the ground that the Senate didn't have jurisdiction. The Republican senators will just say, whatever we may view the actions of the president on December 6th, there's just no jurisdiction. So they'll vote to acquit on jurisdictional grounds. And then 50 years from now, people will point to this as a precedent for putting a future president on trial. And if I'm still around, I'm going to say, no, it's not a precedent. Or you can play my tape. It's not a precedent because there'll be an acquittal. And when you have an acquittal based on jurisdictional grounds, that doesn't serve as a very strong precedent for the Senate having the jurisdiction. So now some pseudo scholars, historians, and constitutional experts have come up with yet another alternative as to how to get Trump, how to take revenge with malice toward all and charity to none. To turn Lincoln's phrase on its head, they have figured out another way. They know they probably won't prevail on impeachment, so they have discovered the 14th Amendment. And they have discovered Section 3 of the 14th Amendment that says that any official of the United States, including a president, takes an oath to support the Constitution. This president did that. And I'll read from the Constitution, shall have engaged in insurrection or rebellion, engaged in insurrection or rebellion against the United States, shall be disqualified from holding any office. Gotcha! You engaged in insurrection and rebellion. No, he didn't. He called for peaceful, patriotic protest. That's the opposite of rebellion. He wasn't there. He didn't go into the House or the Senate. He didn't steal Nancy Pelosi's laptop. He didn't beat up anybody. He didn't engage in an insurrection. But for these pseudo-scholars, it doesn't matter. They have found something in the Constitution which gives them a hook to hang their partisan hat. Well, if you don't like that part of the Constitution, they got another one for you. Hey, here it is. Okay, in addition to have engaged in insurrection of the state, there's an or given aid or comfort to the enemies thereof, the enemies of the state. So now what they're going to say is he gave aid and comfort because he didn't condemn them strongly enough. He said they were good people, and they're going to call people who engaged in protests, even if they're illegal protests, enemies of the state. Now, that's not going to divide people. That's going to be healing. That's going to be really, really effective in trying to bring people together. You're going to call them enemies of the state. And you're going to try to disqualify the former president from running for office again because he participated in an insurrection or rebellion and gave aid and comfort to the enemies thereof. You know, this is Joseph Stalin and Lavrenti Beria. I'm sorry. Remember, I've quoted this over and over again because it's the essence of totalitarianism. Stalin, the horrible, bloodthirsty dictator, and Lavrenti Beria, the head of the KGB, the man who killed all the people on his behalf, are sitting around and reportedly, Beria says to Stalin, show me the man, point out the man, show me the man, and I'll find you the crime. That's what these guys are doing. They have seen the man. The man's name is Donald John Trump. And they're searching through every book. They're finding a crime. They're finding a basis for impeachment. They couldn't find it in the clause of the Constitution calling for impeachment, but now they found it in Article 14th Amendment, Section 3. And what's so magical about that is it doesn't require 2/3, they say. It only requires a majority. Now, there's a saving provision. It says Congress may, by a vote of 2/3 of each house, remove such disability, but first they have to impose such disability. The Constitution doesn't say how it should get imposed, and there are no rules, as far as I know, in the Senate or the House as to how to declare that somebody is engaged in insurrection. The normal course would be if they're convicted of a crime. But let's remember what this amendment was designed to do. It was designed to prevent Robert E. Lee from running for president. It was designed to prevent the generals in the Civil War, those who engaged literally, physically, kinetically in rebellion, those who took up arms against the United States. Every one of them could have been hanged. They all committed treason. I mean, that is treason under the constitutional definition of the United States. They committed treason, they committed rebellion, they committed insurrection. They committed all the things that the people, the jerks and the unlawful people who went into the Senate and the House and the Capitol the other day did not do. They committed actual rebellion. There was a war. They attacked Fort Sumter. 500,000 people were killed. It was a horrible, horrible horrible experience in American history. And the 14th Amendment was clearly designed to prevent those people who participated in the Civil War from running for office. It was not designed as a substitute for impeachment. It was not designed as a Stalin barrier way of let's look through the books, let's find a way of getting Trump. We'll get him one way or another. If we can't find him this way, we'll find another statute. And I wonder what else they're going to come up with. I'm sure there are obscure provisions somewhere in the federal code, somewhere, somehow, that would maybe arguably apply. But, I can tell you what's going on now with scholars is so disturbing. And it's so disturbing what's going on in legal education and education in general. People are being taught tribism. People are being taught to interpret the Constitution the way Professor Lawrence Tribe has interpreted the Constitution now for 50 years. Here's the way you do it. You join a political party. You accept an ideology. You swear an oath of allegiance, essentially, to that political party. You become, as Tribe became, kind of the attorney general in dissent from the Trump administration. And then what your job is to come to conclusions that help your party, that help your ideology, that hurt the opposition, political conclusions, ideological conclusions, and then search the Constitution, change the Constitution, stretch the Constitution, shrink the Constitution to fit your ideology. I challenge Professor Tribe to come on this show and debate me on that issue, because that's been his modus operandi for 50 years. And it's spreading. Jamie Raskin was one of his students. Adam Schiff was one of his students. You could see it in their actions. You can see tribism dominating constitutional thought on the hard left in America, and demanding that the Constitution always be interpreted to come out the right way, always be interpreted to come out the way you prefer, the way your ideology prefers, and the way your politics demands. To me, as a constitutional scholar and expert, it's so obvious, it's transparent, it's laughable. And many of my academic colleagues know that, and they laugh at what Tribe is doing. It's so obvious, so superficial, and so transparent. But for people watching on CNN, they see a scholar, they see a professor, they see a person who wrote a book on the Constitution, and they say, wow, he thinks the Constitution comes out this way. He's probably right. He has no bias or no subjectivity. He's just an objective scholar. Nothing could be further from the truth. I mean, the best example, of course, is when Clinton was president and Tribe used his constitutional analysis to tell the American public that you couldn't prosecute or try a sitting president. The Constitution absolutely prohibited that when the president's name was Clinton. But when the president's name became Trump, Tribe reconsidered and found an epiphany. And sure enough, if the president's name is Trump, now Tribe says the Constitution does permit him to be tried, prosecuted, and convicted. And we've seen that over and over and over and over again with Tribe and his ilk. Manhandling the Constitution, misinterpreting the Constitution, stretching the Constitution, shrinking the Constitution, just to make sure it comes out their way. I see the same thing with historians. Some of these people who call themselves presidential historians, it sounds like they've been appointed by a president. They're historians that study the presidency, just like some historians study the legislature. Some historians study immigration. Some historians study the history of sewage throughout the world. That doesn't make you presidential if you're a historian of presidents. But these guys get on television and they rewrite history to come out their way. And they rewrite the law. It's a real problem of what's going on with academia today. And the students are the victims. Now, many of them are willing victims. They love to go to class and hear a teacher reaffirm their views, tell them what they want to hear. When I taught at Harvard for 50 years, I would start every class by saying, you're not going to hear from me what you want to hear. Every one of your values is going to be questioned. Every one of your opinions is going to be challenged. Every one of your ideologies is going to be put to a test. I'm not going to let you get away with anything in this class. You have to prove everything. You have to argue in favor of your position soundly and coherently. I have no position. As a professor, I'm an agnostic. I take no position except I play devil's advocate. But you're not going to hear from me an ideological imposition of my views on how I interpret the law or interpret the Constitution. But today it's very different. And students now tell me they get graded down for saying things that oppose the ideology of the professor. They don't get recommendations. I have an interesting story about that. Go back. I just thought about this now. When I was a student at Yale Law School, my favorite professor, among others, but one of my favorite professors was Professor Alex Bickel, a great constitutional scholar, really objective, really neutral, called it as he saw it. Terrific, terrific teacher. And I loved his classes, and I would sit there and argue with him in seminars and classes. And then I applied for a law clerkship. And at the time, the judge I wanted a clerk for was Justice Hugo Black, who was the most liberal justice on the Supreme Court. I was the most liberal student at Yale Law School, and so it looked like a perfect match. But there was a professor there named Fred Rodell, who was very close to Hugo Black. And he hated Professor Bickel. And so he actually got on the train, went from New Haven to Washington to persuade Justice Black, even though I was first in my class and editor-in-chief and an obvious candidate for a Supreme Court law clerkship, that he shouldn't hire me because I was a student of Bickel and I interpreted the Constitution the way Felix Frankfurter, his archenemy, interpreted the Constitution. Again, it's not true. I was much more consistent with Black's views than Frankfurter's views, but I was a student of Alex Bickel. And so he went and literally tried to deprive me of my clerkship. It failed. I was offered a clerkship, both by Justice Hugo Black and by Justice Arthur Goldberg, and I took the Goldberg clerkship. But we're talking now almost 60 years ago, professors, Fred Rodell, trying to use his ideology to blackball a potential law clerk for the Supreme Court. If that was happening 60 years ago, can you imagine what must be happening today? The pressure on students to conform to ideological views that will get them the recommendations, the jobs, the clerkships. It's really today dangerous to be a dissenter on a university campus. Whether you're a faculty member, you'll get very bad evaluations. If you're an assistant professor, you may not get promoted. If you're a student, you may not get recommendations. We have to fight back against that. That's not what the academy is supposed to be. That's not what the media is supposed to be. And so on the Dershow, like in my classes for 50 years, you'll always hear an objective point of view. And you can always test me because I make predictions. I put it out there. If I'm wrong, you'll find out that I'm wrong. And I will acknowledge it on this show. If I'm wrong about my predictions regarding the impeachment, we will play back the tape of me saying it. I will admit that I was wrong, but I'm going to make another prediction. I'm right, not wrong, and I'm not going to have to apologize. You never hear Tubin apologize. You never hear Tribe apologize. You never hear some of the others apologize when they're wrong. I've urged over and over again the media to play the predictions and then let the viewers evaluate the accuracy of those making the predictions, but you never hear that. But I'm going to do that, and so if I'm wrong, you'll hear an apology from me. But again, my prediction, I'm right. So let's move forward now. Let's hear from you. Let's hear about your predictions, your judgments, your assessments, your evaluations of me on the Dershow. Let's turn now to our first call of the day.
Hello, good sir. My name is Matt. I live in South Texas. I really like listening to your perspective, and I didn't vote for Trump, but I didn't vote for Biden either. I don't like the two-party system. So I didn't call yesterday because you were asking for Trump voters. My question is, when you're asking about bringing the country together, as someone who votes outside the system, when Joe Biden's surrogates are running out this fast and calling libertarians domestic terrorists, how can he heal the country? Because they're after everybody. And I don't think that Joe Biden is going to spend his political capital on getting social media in line. They're not going to bring Parler back. They're not going to reinstate Trump because they all benefit from it. So what do disaffected people like me even do with it? Like, we already say enough is enough.
It's a great question. We do have a two-party system. It was recently speculated that maybe former President Trump will form a third party. That was tried by Theodore Roosevelt, Bull Moose Party. It didn't work. Third parties have generally tilted elections away from the candidates they more supported to candidates they opposed. Bill Clinton was elected in part by the fact that a third party caused some of the voters who would have voted against him to vote for a third party. So it's very, very difficult. And look, I agree with you that we're not doing enough to appeal to independent voters. I was surprised, a bit disappointed, when President Biden said yesterday that the impeachment has to go forward, that it's important that it go forward. I wish he had taken no position. When it was announced that Vice President Harris was not going to preside, I thought that was a good sign. I thought that was a sign that the administration doesn't want to be perceived as taking part in this impeachment. But then, right at the same time, President Biden announced that he thinks the impeachment should go forward. So I think he could do more to unite the people. I think stopping the impeachment will be a step forward. But even if the impeachment goes forward and produces an acquittal, which is the likely result, I think he can continue to heal the country and do more. But you're right, he has to take into account people who didn't vote for either candidate. And that's a hard thing to do in our two-party system.
Yeah, my question is, Mr. Alan Dershowitz, how can you say that you don't think the 80 million votes weren't fraudulent when the hackers hacked into the machine in Georgia right during the meeting going on and proved that they were accessible from the internet, which being the case, in my opinion, could change the 80 million to 50 million or whatever number they wanted it to be. So my question is, how can you say that the election was legitimate?
Look, I wish we had a voter integrity panel which could answer some of these questions. I haven't seen the evidence that supports your position. And of course, we now know that Rudy Giuliani and Sidney Powell are being sued for many, many, many hundreds of millions of dollars for making essentially those claims against Dominion. So if there is a trial, we'll hear evidence. And all the defendants have to prove, Giuliani and Powell, is that they had a good faith belief that what they said was true. And if they can do that, they very well may prevail in a defamation lawsuit. But right now, it's your word against somebody else's word, against Fox, against CNN, and people like me who really want to get to the truth and want to learn the facts. We're up in the air. I'm going to presume, as I have, that the election was fair enough to the extent that whatever problems there were didn't affect the outcome of the election, but I maintain an open mind. I doubt my opinion will change, but if there is evidence to the contrary, obviously it will change. I always follow the science, follow the evidence, and follow the law.
Hello, Professor. This is Dan from Philadelphia. Your position that a former president and current private citizen cannot be impeached, nor that an impeachment trial can occur for that ex-president, is a persuasive one based on the clear reading of the constitutional text. Of course, the Democrats are arguing that they can still proceed with the trial because of the Article 1, Section 3 clause of, quote, disqualification to hold and enjoy any office of honor, unquote. Democratic Party leaders have stated that they want to prevent Trump from being able to run for president again. My question is, what if Trump had served not one but 2 terms? Your position on that matter obviously would not change, but would the Democrats have any possible justification for holding a trial in that case, since there would be no available constitutional remedy of any kind upon a potential conviction? This goes on the assumption that Trump would not be interested in running for a lower office in the future. I'm curious what your thoughts are on this. I've been a big fan of yours for decades and have many of your books. Love the show. Thanks for your consideration. Be well.
What a great question. Really, really an interesting question. I think one of the reasons that they didn't try to impeach Nixon is under the 22nd Amendment. He could not run because the 22nd Amendment says if you've run and won twice, you can't run for a third term, even if you left office early in your second term. But you mentioned the caveat at the end, running for a lower office. We know that John Quincy Adams, after he was defeated by Andrew Jackson for president, served with great distinction in the House of Representatives for many years. By the way, during that period of time, the House of Representatives was a higher position in many ways than the Senate, because the House of Representatives was the people's house, whereas the Senate was the state legislature's house. So we know that that's a possibility, and I don't think Donald Trump's going to run for the Senate. I don't think he's going to run for the House of Representatives. And he couldn't be precluded from running for mayor of New York. I don't think he's going to do that either. But it would change the dynamic, I think. And I doubt we would see the same pressures being put by the Democrats to disqualify him if they didn't think he was a potential candidate for the presidency in 2024. Great question. It combines, law, politics, and real insights. So that's the kind of question I love. Thanks a lot.
Alan, my name is Roberta. I'm a retired government attorney, and I live in Orange County, California. I just received an email which alerted us that the Chief Justice has refused to be the hearing officer at the impeachment trial in the Senate. The Constitution specifically designates him as the person in front of whom this trial should begin. It gives no procedure for alternatives. However, Schumer and McConnell have decided that they have the right to determine the alternatives and have done so. I believe this is unconstitutional and denies President Donald Trump of his due process rights and equal protection rights. What is your feeling about the actions of the Chief Justice and the actions taken by Schumer and McConnell? Thank you very much. Goodbye.
Another great question. The Constitution provides that the Chief Justice shall preside when the president's on trial. Now, the president was impeached. He was impeached as president. We know that because the article of impeachment was brought forward and it talked about President Trump being removed. So one could make a plausible argument that since he was impeached as president, he's being tried for what he did as president, and therefore the Chief Justice should preside. The Chief Justice obviously reads the Constitution differently, and I think I agree with the Chief Justice's reading of the Constitution, but that does put citizen Donald John Trump in a position where he's not getting an objective, neutral presiding officer, which is what was intended when a president is on trial. Obviously, the framers didn't think this one through because it never occurred to them that anybody would want to put a former president on trial for impeachment once he's been removed. And so I think his lawyers may very well make a motion saying, no, he can't preside. He's not an appropriate officer. He is biased. He's on one side of the political spectrum. He already voted for impeachment once. We need a judicial officer. We need an objective, neutral person to preside. I don't think that motion will succeed, but it's a plausible motion. And I think what you pointed to is yet more evidence that the framers did not intend for a former president to be placed on trial, because if they did, they would have indicated that the Chief Justice should preside, whether it's a current president or a former president. They didn't do that, thus strongly suggesting to me they had no intention of allowing a former president, a private citizen, to be subjected to a bill of attainder, which is what is going on in the Senate right now. So that's all the questions for the Dershow today. This is Prediction Central. I'm putting myself out there. I'm making predictions. You heard my predictions. You've seen my crystal ball. And I'm going to continue to make predictions, and you can judge me on the basis of how accurate my predictions are. But I want to hear from you. I want to make sure you have your say. So please call into the Dershow. Please write in on Rumble. Please subscribe on Rumble and YouTube. The more subscriptions we have, the more people we can get to. And I know many of you like what you hear on the Dershow. I like hearing from you on the Dershow. So let's continue this great seminar and this great dialogue during these fascinating, interesting, and dangerous times. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.